Again, just thank you everyone for being here this morning. We greatly appreciate it. We're going to go ahead and call the meeting to order. 9 o'clock. We would ask everyone to mute their microphones and only turn them on when they speak. When you do speak, we'd greatly appreciate it if you could announce your name so that your names can be appropriately recorded. Moving on to item number B, roll call. Ms. Lopez Sparks has indicated we do have a quorum. We do have two new board members. Greatly appreciate them participating. Mr. Beisel from Houston is here. And a public member, Ms. Carolyn McMahon, was unable to be here today, but will be joining us in the future. Again, just thank you everyone for being here this morning. Ms. Lopez Sparks, would you please do the roll call?
Yes, sir. Christopher Beisel. Present. Mr. Richard Davila.
Present, sorry.
I'm here.
Mr. Gary Hahn.
Here.
Ms. Amy Trost.
Present.
Ms. Stewart. I believe she's here. Mr. Dustin Potter.
I'm here.
Dr. Fowler is absent today. And Presiding Officer Lance Brooks.
Present.
You have a quorum, sir.
Thank you so much. And again, thank you everyone for being here and taking your time to participate in this. I did want to give an opportunity for Mr. Beisel to introduce himself to the board, if you would.
Sure. I'm Chris Beisel, longtime dispenser in Texas. This is into my 35th year, third generation. Started working with my father in 1989, and our practice is in Southwest Houston. We just have one office here in Meyerland, right at Beach Nut and Loop 610. And happy to be involved. Lance asked me if I'd join, and happy to be a part of it.
We certainly do appreciate that. Thank you very much. We are going to move on to item number C, the open government training. Ms. Wendy Pello is the Assistant General Counsel, and she was going to cover that for us. Please, ma'am.
Great. Good morning, Wendy Pello, Senior Assistant General Counsel. We'll be giving the open government training today. Recognize we went through this at the August 30th meeting, but we have some new members, so we will review that. I'm going to share my screen, so just give me a moment to pull that up. And are you all able to see the presentation?
Yes, ma'am.
Okay, great. Thank you. This is a presentation that we give and do a refresher every so often with the advisory board members, but also when we have new advisory board members. We try and hit some, three key acts that are important and relevant to our advisory boards, being the Open Meetings Act, the Administrative Procedure Act as it relates to rulemaking, and the Public Information Act as well. And so we'll start out with the Open Meetings Act, and just as not in depth, but kind of high level, you also have documents in your advisory materials that provide more details about each of these acts, but we do want to hit a few highlights to kick off this meeting. Really, the purpose of the Open Meetings Act is to ensure open and transparent government. Requires that meetings of governmental bodies be open to the public, and that we provide public notice prior to those meetings in terms of the time, place, and the subject matter that will be discussed during that meeting. And the Act is construed liberally to err on the side of in favor of open government. One of the important things is quorum. We do have a quorum today, which is important. At our last meeting, we didn't, which when that happens, it limits the ability of the advisory board to take any action, make any recommendations, take any votes. So quorum is important. And a quorum is basically a majority of the members on that board or committee, and that can be either fixed by statute or rule. And they must meet, must be a quorum present in order to take official action. So if less than quorum meets, you can have a discussion, but we can't take official action, and we saw that at the August 30th meeting. deliberation, and it's a discussion. And it can be verbal or written exchange of a quorum of the advisory members or advisory members another person regarding issues that were within the jurisdiction of that advisory board. A meeting is another key concept here, and a meeting occurs anytime there's a quorum of the governmental body, in this case the advisory board, and they're engaged in a discussion regarding public business or issues that are before the advisory board. And notice is another key thing, and this is we always post their notice, and we post our notices in the form of agendas. And so it has to be filed at least 7 days before the meeting, posted through the Secretary of State, and we also post it on the TLR website. And we can't engage in any discussions about a subject that's not on the agenda. So that's important. We've provided information on the agenda so the public knows what to expect, what will be discussed at the meeting. Keep in mind that meetings can occur in a variety of ways. We often get questions about, especially with advisory boards that, members that are members of other professional associations. You may see each other at conferences and conventions, or do you have to avoid each other? Can you ever meet in an informal setting? And you can meet, but you have to be very careful to if you're talking about the conference, but you can't engage in a discussion about the advisory board business if you've got a quorum of those members involved. So be very conscious of that in those types of situations. Always be, like I said, always be aware of a situation occurring with a properly noticed meeting, and don't engage in those substantive conversations relating to board business or policy when there's a quorum involved and you're outside of an officially noticed meeting. And this last bullet point is beware of the walking quorum. And a walking quorum is basically when you have members that less than a quorum, have a discussion and talk about official business, and then what happens is one or more of those people then communicates verbally or written to other members outside of that original group, such that you end up having a quorum of members meeting. And so basically it's a walking quorum because the discussion has walked from person to person on that advisory board outside beyond less than a quorum, and now you've got a quorum and you've discussing official business outside of a public member. An example for this advisory board, you have 9 members, and so 4 members, you could be talking, exchanging calls, emails. You could be meeting in a work group setting. We always make sure our work groups are less than a quorum so we don't end up walking quorums. But what happens in that situation, whatever those discussions may be, one of those board members who's part of that initial discussion forwards that exchange, whether it be verbally or written, to another board member, and now you've engaged in a walking quorum by having a small discussion outside of the noticed meeting, and the conversation is walked. And so that's one of those things when we do work groups, we're always mindful, make sure we have less than a quorum, and when we have those meetings, caution members don't talk to other advisory board members about this until we come back to a full advisory board meeting and have a properly noticed agenda item to have those discussions with the full group. And again, you've got a variety of ways walking quorums can happen, conference calls, video conference. The bigger issues these days are email, text messages, posting notices on various social media sites. So need to be very mindful of that. And just basically, best practices to avoid that walking quorum. Don't meet in small groups and then let those communications walk or be transferred to other board members that are part of the initial conversation. Don't be sending emails or texts to a quorum. Even if you send them individually, you still, even if everyone's not on a group email, but you've sent the conversation individually, you can't do that. Be mindful of creating any post on social media where that will allow other board members to weigh in on that post. And then also avoid asking a quorum of members, even on an individual basis, for feedback or comments outside the public members, and called polling, and basically trying to get an idea of how they may vote. And it's kind of an informal vote. And so that's what advisory members should not do that as well. Guidelines just for open sessions and just entering the discussions on the agenda. Like we have our agenda notice for today about what we will discuss. There's always a place on the agenda for public comment, so the members of the public can give an opportunity to provide a public comment. However, if that public comment is not on an issue that's noticed on the agenda, you can't have a discussion about that public comment. And if you want to have that discussion about that public comment, it'd have to be placed on the agenda for a future meeting. And again, best practices for just conducting those open meetings is making sure you're limiting your discussions to specific items that are on the agenda. Kind of avoid allowing those discussions to wander off course. Sometimes you can have a good discussion about an issue and it kind of generates more discussion and more issues. And so we need to make sure we keep that reined into what was noticed on the agenda. That way the public knows what would be discussed. Don't respond to discussed issues raised during public comment that are on the agenda, and then identify any issues for future agendas you want to be. It's not that we can't ever talk about an issue, it's just that we need to properly notice it on the agenda for future meetings so the public is aware of what the discussions will be. And it's really important to keep in mind of this because there's both civil and criminal penalties. Civil remedies can be that they can take action to stop any actions that were in violation of the Open Meetings Act, and any actions that we take in violation that were taken in violation of an act are voidable. So which they can be voided. You have to start again to correct and remedy that. So we don't want that. And then there's criminal penalties as well for persons that are knowingly participate in a quorum as well, and that can be fines, jail, confinement in county jail, or both. And so we do want to stress that there's consequences to violations of the Open Meetings Act. So just some best practices: avoid communications following a quorum outside of a properly noticed meeting, and during the meetings, and find the discussions to items specifically on the agenda. And then there's some resources. The Attorney General has training information and training videos. There's AG's handbook giving you a cite to the statute. And again, you can also have any questions or concerns about any communications, give us a call before you have those conversations, and we can help advise on that in terms of giving you some guidance of how to have communications that don't end up violating the Open Meetings Act. The next is the Administrative Procedure Act. This is an act that's basically establishing minimum uniform standards and practices across agencies. The APA, also known as the APA, has a variety of subjects for purposes for the advisory boards. It's important for purposes of the rulemaking process and ensuring public participation and transparency in the rulemaking process. And so, a rule is basically a statement of general applicability that implements, interprets, or prescribes law or policy and describes the procedure or practice to the state agency. It can be a new rule, amendments to an existing rule, or repeal of a rule. And it's basically dealing with the rules of how we are our interactions with licensees and the public. It's not TLR's internal policies or practices. And ways we have rulemaking, we have legislative changes, which is today's agenda item. You've got we're proposing rules, discussing rules that are implementing Senate Bill 2017 from the past legislative session. So that's a good example. We have a lot of that going on right now in the agency following the 80th legislative session. We also have advisory board. Ideas can come from advisory boards, TLR staff. The 4-year rule review, which as it says, every 4 years, the agency reviews each of its rule chapters, determines if those reasons for adopting those rules are still necessary or any changes made, so they can be identified during then. And then a rule petition. And a rule petition is any interested party that may submit a petition to an agency requesting adoption of a rule. And this is an interested party or interested person is a Texas resident, business located in Texas, a governmental subdivision in Texas, or a public or private organization that's located in Texas. And this next slide kind of sets out kind of the process, the workflow for rulemaking. This kind of sets out TDLR's process that has the requirements of the APA, but also elements that TDLR builds in with our use of our advisory boards. Also involves other requirements that are set out in other statutes or directives from the governor's office. And so going through this, we start with ideas of drafting. This may involve work groups depending on advisory work groups depending on the subject matter and the issues going on. We have internal review and analysis where we're doing fiscal impact forms because we always have to set out what the impact financially will be to the state and to interested parties that would have to comply. Proposed rules go to the governor's office review, and that first blue box up on the top row is that first advisory board meeting with our advisory boards. And we're discussing setting out those rules and hopefully getting a recommendation before publishing the proposed rules in the Texas Register, and where they're open for public comment. And those are open for at least 30 days. And then the review of the public comments. And we get to this second blue box, the second advisory board meeting, which is where we are today in the process for this advisory board for this particular set of rules. We'll have those discussions in a little bit. The agenda item later on the agenda, discuss the proposed rules and the public comments are received, get your input from the advisory board, and then hopefully get a recommendation about those rules going to the commission, and where the commission will consider those rules. They'll be adopted by the commission, then filing that all the adoption notice with the Texas Register so the public knows, and then having the effective date of those rules. So it's kind of a very high level of kind of the workflow and the process that goes through a rulemaking. And this sets out just kind of the rule review process. This is the 4-year rule review process in terms of, like I said, it starts every 4 years. When we do that rule review, we just publish a notice of intent to review. We don't publish any proposed changes. There's no strike-throughs, underlines, no new rules. It's just putting the public on notice that we are proposing, or that we're going to be reviewing the rules, and that they can submit comments, if they think if they agree the rules are still necessary, or are there any changes that need to be made, so the public is to weigh in on that. We're reviewing those comments and then taking the rule chapter to the commission where they may readopt the rule chapter, and if there's specific rule changes that are identified during that process, those would be proposed in a future rulemaking, just using that standard rulemaking process for the previous slide. It may involve advisory board, depending on what those comments are, may advise the advisory board on getting technical expertise if we get some technical type of changes in that. And again, we have resources here listed here, and also in your materials, more about the rulemaking process. And again, you can always call the TDLR's General Counsel office if you have questions. And finally is the Public Information Act. Again, open and transparent government is kind of the key in making sure that information kind of about what the government is doing is open, and our records are open to the public, there's some exceptions. But it is important to note that the public information can include any electronic communication created, transmitted, received, maintained on any device in connection with official agency business. And again, this act is construed liberally in terms of granting requests for information. You may be wondering, why is this important to the advisory board members? Well, folks may know that you are a member of the advisory board, so they may come to you with requests for information and documents. If you receive those requests, and the request has to be in writing, it's not a verbal request, must be in writing for records or correspondence. But if you get one of those, or you receive one of those, forward that information to the General Counsel's office or to the advisory board team as soon as possible. And if we ask you for information, if we get requests and we need information from you all, please respond as soon as possible. And the reason for that is the Public Information Act states that state agencies must respond to a request as soon as possible, but not later than 10 business days after receiving that request. So we need to gather the information and determine what is relevant to provide and to respond appropriately. If we need to receive any clarifications on that. We can't ask why someone wants the records, but we can ask, our General Counsel Office or Open Records team can ask for clarifications if it's not clear from what the requester is needing. And again, there's some common exceptions. Like I said, the general rule is presumption of openness, but then there's certain things that must be redacted, must be, date of birth, certain, email address, certain most email addresses, driver's license numbers, HIPAA information. And then there's information that may be withheld, but we have to submit a request to the Attorney General. So part of that is, again, with the timeliness of making sure we can respond to the request and provide the information we need to provide and file any exceptions if we need to file any exceptions. So that's important. Just to let you all know, again, you may get those requests just because people know you're on the advisory board. So wanted you to be mindful of that. And again, we've got resources here. The AG's office has a training video and handbook that is helpful in that information. And again, other resources. And again, the General Counsel's office, our phone number is there as well. So that concludes the training on that.
Very good. Thank you, Ms. Pello. So, yes, ma'am.
I just want to see if I'm still sharing or if I'm.
It says end of
We just see
slideshow.
Yeah, we see a black screen, Wendy. There you go. Now you're good.
There we go. Thank you all.
Very good. Thank you again.
You're welcome.
So we want to move on to item number D, the approval of the minutes from the meeting of November 9, 2021. Those were attached in the materials that were sent. Are there any comments?
I make a motion to approve the minutes. Amy Trost.
Thank you. Is there a second?
A second.
Mr. Hahn, you second that?
Thank you.
Yes.
All right. Ms. Lopez Sparks, would you mind calling
Yes,
for
sir.
a roll call?
Christopher Beisel,
4.
Mr. Richard Davila,
4.
Mr. Gary Hahn,
4.
Miss Amy Trost,
4.
Mr. Dustin Potter,
4.
and Presiding Officer Lance Brooks.
Yes, 4.
Motion passes.
Thank you. Thank
Mhm.
you. It's great to have a quorum so we can pass the minutes from that last meeting. So thank you very much again for being here. Item number E is a public comment that was made. Ms. Pello mentioned that some of the comments will be discussed in one of the items a little bit later on. This one was received and it will not be read aloud in today's meeting. Moving on to item number F, discussion and possible recommendation on the proposed amendments to existing rules of the Texas Administrative Code. The proposed rules implement changes made to the Texas Occupational Code, Chapter 402, Senate Bill 2017, 88th Legislature Regular Session. Implement the changes made by the U.S. Food and Drug Administration in its final rule regarding over-the-counter hearing aids and prescription hearing aids. Make changes to provide continuing education credit for proctors of the practical test and update language to reference the department's website and contracts and signs. This agenda item includes discussion of the public comments received on the proposed rules. Ms. Pello, would you mind leading us through that, please?
Yes, I will. Thank you. Wendy Pello, Senior Assistant General Counsel. The proposed rules you have, we had looked at that at the August 30th meeting and Nick had walked through that. I can, not since everyone's here, I can briefly give a quick run through of those and then talk about the public comments. These rules are primarily implementing Senate Bill 2017 from this past, from the regular Texas legislative session this year. The changes are implementing the changes from the U.S. Food and Drug Administration, FDA, rules on over-the-counter hearing aids as part of those changes. And again, those FDA rules were being we're implementing the federal law, the FDA Reauthorization Act from 2017, which created, that there would be this over-the-counter category of hearing aids. The FDA would make those classifications, they would implement rules, and then there was provisions about preemptions of existing or future laws about, laws that would interfere or restrict any activities related to over-the-counter hearing aid, including requiring any type of licensing for over-the-counter hearing aids. So changes were made in Senate Bill 2017 to implement those federal changes, both the federal law and the reflecting the changes made at the federal law and the FDA rules. And now these rules, the TDLR rules for the hearing instrument fitters and dispensers, are implementing the changes made to Occupations Code Chapter 402 related to those over-the-counter hearing aids. I will share my screen here for just a second and quickly run through those rules. There are some other few other cleanup changes that were made in these rules, but that's kind of the bulk of those changes. Again, can you all see my screen? Confirm.
Yes, ma'am.
Okay, great, thank you. Just quickly going through these rules, we did had the last meeting that we're not able to get a recommendation from the advisory board, but the department moved forward with proposing the rules without a recommendation, and hopefully we can get a recommendation from the advisory board today before going to the commission. One of the things about Senate Bill 2017 required that the rules, as they related to changes related to contracts and signage that were part of Senate Bill 2017, those rules had to be adopted no later than December 1st, 2023. So it's kind of in a tight timeline. We did publish those rules on September 22nd, as you can see at the top of this draft, and they were open for public comment until October 23rd, so last week. One of the big things in these rules was changes to definitions, and again, this is coming from the FDA over-the-counter hearing aids. We've made an update to fitting and dispensing hearing instruments. So made some necessary changes there, but the big changes were the definition of adding a definition of hearing aid. And hearing aid, now that they're with the FDA classification, and now there's over-the-counter hearing aids and prescription hearing aids, and anything that's not an over-the-counter hearing aid is classified under those FDA's requirements is a prescription hearing aid. So it was important to have hearing aid is the umbrella term, includes both prescription hearing aids, which is also hearing instruments, and over-the-counter hearing aids. Hearing instrument now under both the statute and the rules is a prescription hearing aid, and that was important because, again, the current statute, the statute pre Senate Bill 2017 was broad and would have been a hearing aid and would have included over-the-counter hearing aids. And so that needed to be changed based on the federal changes at the federal level. And so hearing instrument has now been redefined both in the statute and here in the rules to be a prescription hearing aid as that's defined under the FDA rules. And again, we've added a definition of over-the-counter hearing aid as well as defined again by the FDA rules. Made cleanup to the definition of sale, and again coming from FDA rules, and some renumbering. So that was a big thing. It was trying to get the definitions in place, and again those are coming from Senate Bill 2017 and the changes made to Occupation Code Chapter 402. Get those in place, and then the rest of the rules follow. And this is another one of the biggest changes is the Rule 112.3, and this is new, and this is over-the-counter hearing aids. And this is talking about the exemption that over-the-counter hearing aids are not included under Chapter 402. We don't regulate those. Those are regulated by the FDA. And so this rule very closely mirrors the provision in the statute, the new provision added to Occupation Code Chapter 402. And then it says, which and then in turn mirrors kind of the FDA rule, Rule 21 CFR, 800 4.30, and there's a provision in there under subsection H in those FDA rules about the effect on state law and the preemption. And so this is kind of, again, just kind of the trickling down from the FDA rules to the statute to the rules. And again, basically this is saying, this, except as provided in this section, this chapter doesn't apply servicing, marketing, selling, dispensing, providing customer support for, acquiring, or distributing over-the-counter hearing aids. And B is saying a person does not need to obtain a license in the chapter to engage in one of these activities. Again, as it relates to over-the-counter hearing aids. Made cleanup, and this is important with the licensed dispenser and licensed seller, because the FDA rules, even before their rule change and after their rule changes, they use the term dispenser, but it's not a licensed dispenser. And so making that clear, somebody can't say that they're a licensed dispenser or a licensed seller, or use another, some other terminology that would indicate that they're licensed, unless they are, licensed as a hearing aids fitter and dispenser, or as an audiology intern. Persons are not required to go to someone who is licensed to have access to over-the-counter hearing aids. Again, coming from the FDA rules and the federal law changes, but that doesn't prevent somebody who is licensed from engaging in activities related to over-the-counter hearings. But they still, because of that, they're not exempt under the chapter from any other applicable provision that's unrelated to over-the-counter hearing aids. So that's a big section. Again, that's coming from the statutory changes and coming from the FDA rules. The continuing education, this was not related to Senate Bill 2017, but this was a change requested by staff and some others involved in the practical test, in terms of offering someone who serves as a proctor may obtain a continuing education hour of credit for each test date, not to exceed 4 continuing education credits per license term, which is 2 years. And this was to encourage and to obtain additional licensed hearing fitters and dispensers to serve as proctors for the practical test. So that's what that changes, again, not related to Senate Bill 2017, but was added as part of this rule package as a necessary change. We've also made updates on the complaint information, directing the clients to the department's website address as opposed to email address for purposes of filing complaints. Our website address has tabs and links for filing complaints versus an email address. So that is the update there. Conditions of sale, again, this is related to the FDA rules, the former FDA rules under 21 CFR 801.420 and 421. These were rules that were talking about red flags, rules talking about medical evaluations and waivers. Those rules were repealed as part of the FDA's rules, and they put in place a new rule 801.422 related to prescription hearing aid labeling. So that we've updated that, and so license holder or permanent holder has to comply with those new federal regulations as they relate to prescription hearing aids. And then the joint rule, and this is a rule that this profession shares with the audiologists under the speech language pathologist and audiologist program. And this is the joint rule. We've made some minor cleanup of, just for clarity purposes, talking about the trial periods. It's relating to a hearing instrument, again, now a prescription hearing aid. So we've made some cleanup there. And then have also made some changes with the a copy of the written forms. This is a waiver form, and this was related to the medical evaluation and waiver form. So, since that was repealed in the FDA rules, we have repealed that here, so that our rules align with those types of requirements. And then down in the record keeping, we have clarified that if a medical evaluation waiver, if provided, then you would retain that. And again, those would be situations in terms of patients 18 years or younger, or situations where there has been evaluation or a waiver evaluation provided, then you would maintain those. So that's kind of the overview of those changes. I didn't know if anyone had any questions on those proposed rules before we dive into the two public comments.
Mr. Davila's hand go up. I'm not sure if he had a
Oh,
question or
okay,
comment.
yes, go ahead.
Well, a motion, which we can still
Okay.
discuss after the motion, and my motion was, I wanted to move to recommend these changes to chapter 112 as proposed to the department.
Okay. Great. If it's all right, I can quickly go through the public comments, raise those issues, if we take consideration, if that's all right with the chair, or
Yep. Thank you, Mr. Davila. I really appreciate that. Ms. Pillow, would you mind, please? Let's just go ahead and cover those, please. Yes.
okay. Yeah, we received two public comments on the proposed rules. One was from an individual, and one was from the Texas Medical Association. The individual had offered a comment on the proposed new rule 112.3. That was the over-the-counter hearing aid new provision about the exception and setting out that this chapter doesn't apply to over-the-counter activities related to over-the-counter hearing aids, and persons are not required to have a license for engaging in those activities related to over-the-counter hearing aids. So the commenter had made some comments saying that certain rules only applied to people living in Texas, but companies and individuals were selling hearing aids to Texas consumers by internet mail. And then they had some questions about why people who live in Texas are required to be licensed, if they want to sell all types of license, and then is Texas license optional and mandatory. And from the department's perspective, we reviewed that comment, but we just agree with the comment and didn't make any changes. One thing is that new rule 112.3 over the county hearing aids is again closely mirroring the statutory changes made by Senate Bill 2017, and that provision is the new provision in the statute. It's found under section 402.004, and again that provision is coming from the FDA rules, which is then implementing the federal law. So basically, it's only applying to over-the-counter hearing aids, and so the proposed rules that we're proposing that are before you today are only affecting over-the-counter hearing aids. They're not making any changes to the licensing requirements under the statute or rules related to prescription hearing aids or hearing instruments. So there's not any changes to that. So we did not make any changes in response to that comment. Didn't know if the advisory board had any comments or additional thoughts on that. Okay. If not, and go to the second comment. The second comment we received from the Texas Medical Association, TMA. This, again, we reviewed the comment, but we're not making any, disagreed kind of with the comments and not making any changes to this. This was a comment for the TA, is like they recognized that the federal rules removed the required medical evaluation for adult prospective hearing aid users, and that the proposed rules, I'm sorry, and let me back up, the TMA comment is a one comment letter or joint comment on both the speech language pathology and audiology rules under chapter 111 of the administrative code, and then the hearing instrument fitters dispensers code under 16 Texas administrative code chapter 112. So they've combined together. Their proposal was making changes to the speech language pathology and audiology rule, but then requesting that the same changes be made to the hearing instrument fitter rules, or doing a cross-reference. And their concern was, again, with the medical evaluation. They thought, even though the federal rule removed that, they were recommending that TLR adopted rules contain the new federal red flag guidelines or conditions when somebody should be medically evaluated. So they were in their comment letter making note that the federal rules remove that, and that they were proposing, and then they noted that we would make those changes, according changes for the audiologist in their rules. And again, they were concerned about leaving people uninformed, so they had made a recommendation to amend the speech language pathologist rule, Rule 111.201, and then you can see their draft language. And then for the hearing instrument fitters and dispensers rule, they wanted to add those same changes to Rule 112.96, which is the conditions of sale. They did note that the language they were proposing tracked the red flag labeling requirements under the new FDA Rule 801.422. Again, we disagreed with that comment and were denied for 3 reasons. One is the TLR rules align with the new federal FDA rules in terms of removing that medical evaluation and waiver provisions for persons 18 and older, and so our rules reflect that. Your all's rules, the hearing instrument fitter and dispenser rules, don't have the exact same medical evaluation waiver provisions, but both sets of rules required compliance with those former FDA rules, 801.420 and 801.421, which is the red flag rules and the medical evaluation and waiver rules. So that we comply with that. This second thing is, at this point in the rulemaking process, we can't be making substantive changes to the rules. I mean, we do make comments based on comments received, may make comments to the proposed rules based on comments received. But if they start affecting new persons, if you have parties that start making substantive changes, making things more stricter, those type of cases, we thought those changes needed to be made. We would need to either withdraw the proposed rules, start over and republish them, or we would have to add them in a future separate rulemaking. We don't think those changes need to be made here, but again, need to be mindful of the extent of changes that can be made based on public comment without affecting new parties or adding substantive requirements. And finally, the thing is we thought this change isn't necessary. The TMA had expressed concern about or wanting to add the red flag conditions from FDA Rule 21 CFR, the new section 801.422 about prescription aid labeling, into your Rule 112.96. However, proposed Rule 112.96 already requires compliance with that FDA rule. So it's already, those red flag conditions are already built into that rule that you're required to comply with. So it's not necessary to separate those out or spell those out. So we were not agreeing to those changes, but it is, again, those red flag conditions are part of that FDA rule, which is, again, part of your Rule 112.96 that requires compliance with that new FDA rule. So open that up for if the advisory board had any comments or questions or additional thoughts on that comment.
Looked like Mr. Davila had his hand raised.
Okay.
Yeah, the same motion. I moved to recommend these changes to Chapter 112 as proposed to the department.
Very good. Any other comments, questions, concerns anyone has? Is there a second?
I'll second that. Dusty Potter.
Thank you, Mr. Potter. All right. Well, Ms. Lopez Sparks, would you mind taking a vote or the roll call on that, please?
Yes. Christopher Beisel,
4.
Richard Davila,
In favor.
Gary Hahn,
Yes, 4.
Amy Trost. You're muted, but I did see your mouth move for 4. Dustin Potter
4.
and presiding officer Lance Brooks.
4.
Motion passes.
Thank you. Thank you very much.
Thank you, Will.
Are there any recommendations on item number G? Any recommendations for topics for the next meeting? If not, we'll move on to item number 6, and Angelica's going to poll the board at a later time for the future board meeting. If there's not any other business that anyone has, Then we will adjourn the meeting at 9:44. And thanks again, everyone who came and for giving us a quorum today and for letting us to participate in this very important process. So thank you very much for being here and your participation. Thank you, everyone from TDLR, for helping us with this process.
Thank you all.
Thank
Happy
you. It's good to
Halloween.
see you all again.
Have a good day, everyone.